In June of 2002, Ron Graham applied for citizenship with the Muskogee Creek Nation Citizenship Board and was denied on January 9, 2003. On December 12, 2003, Mr. Graham filed a petition in the MCN District Court asserting that the Citizenship Board had acted arbitrarily and capriciously in denying his citizenship application. Over the next 3 years, a series of administrative reviews and court filings culminated in a multi-day trial in the district court. March 17, 2006, the court issued an order finding that the election board had not considered and applied MCN laws that were in effect at the time the application was initially presented, and thus acted in an arbitrary and capricious manner. The MCN Citizenship Board was ordered to apply NCA 81-06 instead of NCA 01-135 in the reconsideration of the application. The Citizenship Board challenged this order at the MCN Supreme Court with a final order appeal filed on April 13, 2006. After review of the case, the MCN Supreme Court issued a single-paragraph order on November 2, 2007, concluding that there was no evidence that the Citizenship Board had acted arbitrarily and capriciously, reversing the district court order and dismissing the case. At this point, there were no further filings in the case for 11 years. Mr. Graham submitted a new application for citizenship on May 30, 2019, referencing the Treaty of 1866, Article 2, as the basis for application. On August 23, the application was again denied, and after another series of administrative reviews and court filings, the case was once again before the MCN Supreme Court. The issues presented before the court in Mr. Graham's notice of appeal filed on January 24, 2020 are as follows. 1. Had Mr. Graham submitted a justiciable case or controversy before the court? And 2. What was the impact of federal case law on MCN courts, specifically the case Cherokee Nation v. Nash, which established that Cherokee freedmen have citizenship rights in the Cherokee Nation under the 1866 treaty? In their September 17th order, the MCN Supreme Court found that due to the elapsed amount of time and the fact that no new arguments were presented to the court, there was no controversy. Furthermore, the court found that the Cherokee versus Nash opinion had only persuasive value to the MCN courts, not controlling authority. Ultimately, the order affirmed the lower district court order, which dismissed the case. Muskogee Media spoke with Ron Graham about the future of his citizenship battle.
So I just want to start off first by kind of just doing a rundown of where we've kind of seen the issue of freedmen and citizenship be with the tribe. We've seen that the freedmen have filed a case before, and that was back in several years back. I can't really recall I don't have my notes right in front of me, but and that case went all the way through district court, and then was kind of shut down, and it was an appeal for freedmen citizenship, basically. And then recently, within the last few years, this other case has been filed where you were appealing again. You went through the process all over again with applying through citizenship, the denial for citizenship, and then you requested an appeal through the court to gain citizenship for the Muskogee Creek Freedmen again. And we've seen that one recently go all the way up through the Muskogee Creek Nation Supreme Court, where basically, can you kind of just give us the rundown of where that case went and where it's at now?
The case at the moment, it has been decided on by the Supreme Court, and they denied us everything. So that's where it stands right now. We can take it outside of the Creek Nation, or take it to federal, or things of that nature, and that's one of the things that we are contemplating on doing. But right now, as it stands, the Supreme Court of the Creek Nation has ruled on it, and so we're just looking to see to take it outside of the Creek.
Can you kind of give us a little bit of a synopsis of that ruling? Because just reading it, it seemed kind of like, they were basing this on like previous cases. What, in your own words, was kind of the ruling of the Muskogee Creek Nation Supreme Court?
The synopsis of what I've read about, and also my attorney, they actually went back and based it on my previous filing for my citizenship back in 2006 or 7, I believe. And that's one of the things I was discouraged about. They didn't really look at all the case laws, such as the Treaty of 1866. So part of the ruling stated that we waited too long for a clarification from the previous filing back in 2006, I believe, 2007. So I was very discouraged about that because there's a lot of case laws now that's been has arose within the Creek Nation. The Creek Nation had a favorable decision by the United States Supreme Court dealing with the Treaty of 1866, Article 3. And my appeal was about the Treaty of 1866, Article 2, which gives me, as a freedman, a person of African descent, the right to become a citizen or a member of the Muskogee Creek Nation.
And this new case that you had filed with, that was the basis of your case, right? This 1866 treaty article. And how is that different from that first case? Because it seems like that was a different kind of, like, I know that the ruling kind of said, you kind of mentioned how this recent ruling based off the first case, but it seems like you introduced a new, argument for the case.
Absolutely. The first case dealt with my genealogy pertaining to my great-great-grandmother, Rose McGilvray. They were saying that this is not the same person. But also I did include my dad at that time in that in the filing for citizenship, because my dad was an original Alati. And they just didn't address they being the earlier court case back in 2006. The Supreme Court did not address that argument. They didn't even pertain to it, not even in their ruling at that time back in 2007. So the new law, I went strictly off of my the paternal side, stating that my citizenship is based on the Treaty of 1866, Article 2. And I plainly stated that on my application also, which states that the people of African descent should have citizenship as natural born citizens, or citizens that was Muskogee Creek citizens already. So I strictly based that on this application right here back in 2019. So again, it was disappointing that the Supreme Court ruled that way.
When we talk about this 1866 treaty, and it has become the center focus of a lot, like you said, of case law, and especially when we've seen the U.S. Supreme Court, uphold these 1866 treaty jurisdictions, do you feel like that impacts your case or your position to apply for citizenship in any way? Does that Supreme Court of the United States decision to uphold Muskogee Creek treaties based on jurisdiction, do you feel like it strengthens or helps with your case at all?
Oh, absolutely. It absolutely strengthens the case, without a doubt. I was thrilled and delighted when I seen that ruling by the United States Supreme Court, because that ruling based its decision on the 1866 Treaty, Article 3. You can go back and read that. That ruling wasn't based on the Oklahoma Indian Warfare Act. That is how the Creek Nation based their constitution on. The Creek Nation Constitution on the Oklahoma Indian Warfare Act back in 1936. Okay, so but what's stronger and superior law than that is the treaty. Period. It's the ultimate and supreme law. Even the U.S. Constitution says that. that all treaties will be the supreme law of the land. So when that United States Supreme Court validated that was a huge victory for every tribe that going by that 1866 treaty. Absolutely, it did strengthen it without a doubt.
And what does that mean for freedmen of the tribe in general? Like when you guys are watching these case laws and everything, what direction do you feel and options do you feel like you have now?
The same options I had back in 2006, when I first started, still basing everything on the treaty. We are still basing everything on the treaty. Like I stated a moment ago, Ms. Ellis, the treaty is the supreme law of the land, period. They can make any law they want to. They can make any constitution that they want to. I believe in sovereignty, okay? I'm 100% for it. But when your sovereignty violates a group of people's rights, that's the problem. And our rights come directly from the Treaty of 1866, Article 2.
Can you kind of give us some scope and understanding of just how many people's rights this impacts? I've heard talk before when you hear people and lawmakers talking about law and they like we've seen this play out in the Supreme Court where the state of Oklahoma pitched this wild and scary scenario, and then sometimes we hear lawmakers saying, "Oh my goodness, suddenly enrolling all the freedmen could be this big, scary, spiraling, numbers wise." Do you have any concept of how many families and people this actually impacts who are looking for citizenship right now?
Well, I don't have a good number. I have a suggested number, and I do believe it's probably like 5,000 to 8,000. But so far, people who's been harmed like me got a denial letter saying that they're not eligible for citizenship. The people who are in the same boat I'm in, that's already got a denial letter from the Muskogee Creek Nation, it's been about close to 100 people who actually submitted an application and got denied by the Citizenship Board. So this is an estimate, 5,000 to 8,000 freedmen, and that may be putting it mild. I just don't know. I don't have the documentation. Me being a genealogist, I deal with documentation. So that's what I would like people to do, Creek Freedmen descendants to do, is to apply for citizenship, knowing that the Citizenship Board at this time will deny them. But although I wish they would, and I would hope they would submit their application. I hope that answered your question, Ms. Ellis.
Yeah, that gives us a good understanding. I don't think that we've never done a records request to see, how many people have had denial letters who might be, Creek Freedmen. But I was just always curious about, like, when we talk about like a person's rights and citizenship, just like, to see that there's been maybe 100 denial letters, that's kind of, what I was kind of looking for as far as information goes. Do you feel like you have any avenues immediately? Like, are there any steps that you're looking to take as far as going like into federal court? If you can talk about that, I'm not sure if that's like something you're able to, give us info on, but I'm just kind of wondering, like, what is the next, steps for organizing or trying to find your solution?
Well, that's the next step, is federal court. I talked to my attorney yesterday because I knew I was going to have this interview with you all. So the next step is federal court. That's it. That's as far I'm gonna go with that comment.
Sure.
But
I totally understand that. We recently saw within the last few years where a case similar was in the district court of DC, and the judge there ruled that tribal remedy needed to be exhausted. Do you feel like you guys, having, like, you in your case having exhausted tribal remedy, you probably have like a leg up there, or maybe a fast track in? Is this something that we might see results in soon, or is it going to be like a long appeals process, is what I'm trying to figure out?
Well, we hope it's not a long appeal process, because just like the Cherokee Nation ruling back in 2017, the federal courts found that the treaty still existed. So hopefully it won't take long, the appeal process. Hopefully they'll just rule on it just like the United States Supreme Court. There's already a ruling about this treaty now, so there should be no hesitation about what's going on with it. We have almost the same treaty of the Seminole Nation and the Cherokee Nation. And right now, the Cherokee Nation and the Seminole Nation do accept their freedmen as citizens or members of that tribe. So, Miss Ellis, I'm hoping and praying that it doesn't be a long process. So that's what we're looking at right now.
Have you heard any feedback from those other tribes as far as once they did, like, I know the Cherokee Nation had the court ruling that said you guys will accept freedmen, in your tribe, and it was kind of decided. Have you heard any feedback on the impact of that? Like how many, freedmen citizens that might have opened the door to citizenship, or is there any good place to find information like that?
I haven't found too much stuff documented, but I've talked to several, probably hundreds of Cherokee freedmen descendants, hundreds of let's say Cherokee citizens in general, by blood or freedmen, it doesn't matter. They welcomed it. They were totally delighted, because it stopped a dilemma of this feud, what's going on. This is an ugly mess, what's going on. They can go in Washington, D.C. and say, okay, we are fully complying with this treaty, because they have accepted their freedmen right now. So to me, the Creek Nation may not could say that. They could say this or that, but they have not fully complied with the treaty. And they're saying that, the United States government didn't do this for us, not doing this for us. It's just an ugly stain on them. I believe, this is from Ron Graham, that if you're not complying with your treaty, why should we do this or something? So yeah, I've gotten a lot of good feedback from the church, especially the Cherokees are 100% behind this, 100, because they truly open the doors for the freedmen. Now, the Seminole Nation, the freedmen only get to vote. That's it. They don't get any benefits or anything of that nature, but they just get to vote. But with the Cherokees, it's something different. And I'm still praying. I'm hoping and praying that the Creek Nation will follow suit with the Cherokee Nation.
Can you kind of give me just like that human side of this, as a person who is descended from a person who held allotment land as a Creek citizen, and to now not be able to enroll, or even experience, maybe someone in your family might need electric assistance or something like that. What is that like? I mean, kind of get me there and show me what you guys are dealing with.
Are you talking about the feeling I feel to not to be enrolled? Or
Yeah.
I'm gonna tell you, this hurts. You know, people are thinking that I just came on the scene a few years ago. I actually applied back in 1983 after my first year of college. I applied. A buddy of mine had told me about getting my card. Uh, and I didn't know anything about it. My dad he died in 1979. So I took it upon myself to go up to the Creek Nation and get my card. And I thought my dad was full-blood Indian because he was traditional. He spoke the language, the traditions, the culture. He was a stomp dance. He was a stomp dance leader. Received his feather. This it was just shocking. I knew my dad. I knew him well. So the language, everything. So it hurt. This hurt right here. Back in 1983. That, and as you can see, I'm still fighting it right now. What I say is educating folks right now on what happened. But it's painful, very painful, even now. So that's how I feel personally. I just want the Creek Nation to just simply go by the treaty. That's it. And that's what the Creek Nation want the government to do. Simply go by the treaty. That's it. And like I said, I believe in sovereignty, and that's how I look at it.
Do you think that, is there any scenario that could play out from here to then that you feel would be better or worse for the Creek Nation as in terms of accepting freedmen citizens? I mean, what I'm kind of wondering is, would it be better for sovereignty if the Creek Nation decided to do this, or if it was mandated by the federal courts?
Oh, without a doubt, the Creek Nation. That's how I feel. But I truly believe now, I truly believe right now, the Creek Nation is not going to do it. And I hate to say that about I was born a Creek citizen. I was born a Creek citizen. 1979, they had a constitution election or something of that nature, okay? But I was born a Creek citizen. I hope and pray that the Creek Nation, and only the Creek Nation, have a change of heart, a change of mind, and do the right thing by fully complying with that treaty. Because if the federal government comes in, we don't know what changes may be done, but we do know that the federal government is going to go strictly by the treaty, because the ruling at the Supreme Court level stated that, you know, making the Muskogee Creek Nation a reservation, still a reservation. And a lot of people may not know where I stay at right now in War Acres, Oklahoma, is a suburb of Oklahoma City. Before the Civil War, this used to be the Creek Nation right here. This was Creek Nation land. After the Civil War, when they made that treaty, they lost a lot of the land, even the other tribes. The eastern part of Oklahoma was no longer the Creek Nation, okay? So saying that is that the Constitution, say it may be, it's their Constitution, but the treaty is what gave us this land, not the Constitution, Muskogee Creek Nation Constitution, not the Oklahoma Indian Welfare Act, because when that came into effect, if the Oklahoma Indian Act was supreme law over the treaty, they would have regained their land back. But they couldn't do that because of the Treaty of 1866. It gave them their land base, and it took that land away from them because they had a treaty. The people of Creek Nation made a treaty with the people of the South, okay? But as you know, the people up north, the Union won the Civil War. That's just a bit of history. But Miss Ellis, I pray and I hope and pray that the Creek Nation does the right thing on its own, and make things right for everybody, not only the freedmen, because we're looking for equal justice, equal citizenship, membership, whatever the case may be, such as we should be able to run for national council. And of course, we should be able to vote, run for national council. If anybody in the tribe, I'm talking about if you're less than 1/4, you have to be a full citizen to be 1/4 or more. But if anyone who's less than 1/4 would like to run for office, let every citizen run for office, period. Just like the United States. The United States lets every U.S. citizen, if you're above 18, or there's certain qualifications, but you will be able and you have the right to run for office, period. In the House of Representatives, senators, governor, a mayor, whatever the case may be. And that's what I hope and pray that the Muskogee Creek Nation does. But first and foremost, they have to go by that treaty, period. The problem that I have seen over the years, the people that's already a citizen of the Creek Nation, they talk about blood quantum. Blood quantum, in my research and studies, it was not given to the freedmen citizenship. What I mean by given, if you were listed on the freedman roll, if you were 1/2 Creek, 1/4 Creek, 1/8, they did not list your blood quantum on your census card, on the card what the Dawes Commission put on, that was given to, such as roll numbers. Okay, and to me, a roll number is like it's equivalent to a social security number. That's what I call the first social security number. Social security came out in 1935 or 1936. I know my grandmother and my father received a number back in 1937. But the roll number is very important because it dealt with land. You had to be a citizen first, and you had to go through a process of getting the roll number, and things of that nature. But and you received the land. Every citizen received 160 acres. Even my dad, he received 160 acres. His land was up there in Creek County in Sapulpa. But the blood quantum is what I have a problem with, and so do a lot of this by blood. Okay, and again, the blood quantum, when the Dawes Commission came up with that, it wasn't that itself was racist to me. Okay, I didn't want to use the R word, but it was racist to me in my studies, in my research, because when you look at it, if you look on the 1900 or 1910 census, there is a column on that census, the U.S. Census, okay, 1900, 1910. It states this Indian, if this Indian have any white blood, how much? So this tells me that, hey, were they really looking for Indian blood or white blood? No, they was looking at the more white blood you had, because the more white blood you had, the more intelligent you were. And that's how they looked at things, they being the government, they being the Europeans, okay? It's documented, and that's what I deal with, folks, documentation. It's called, and they later made a law. It's called the Burke Act, B-U-R-K-E, Burke Act. You had to be competent, incapable of handling your affairs. Folks, that blood quantum, it totally worked against us. Us as a nation, not us just being freedmen. I'm talking about us as a nation, period. The the government wanted us eliminated, the whole nation. That's how it was. And I pray, hope and pray we don't fall into that. We have fallen into that. That's what happened back in 1979 in that Constitution. And this is in my studies. But if you like, just look, do your research. Simply do your research. And you can Google that act and read that act. Again, it's the Burke Act, Burke. And that's the only downfall. We wouldn't even be having this conversation if they wouldn't have placed a blood quantum on the citizens of any tribe, not only the Creek Nation, but of any tribe. They would not, if there was no blood quantum nowhere, we would not be having this conversation. We would be one nation as we supposed to be, period. So that treaty settles it. It was said in the treaty, and it settles it. The treaty is like the U.S. Constitution right now. When you look at the 13th, 14th, and 15th Amendment, which deals with slavery, people of African descent to vote, that's what it says in Article 2 of the Treaty of the Creek Nation. So compare the two. Compare the United States Constitution with the Muskogee Creek Nation Treaty. Article 2 of that treaty. I believe it's like 20 articles in the treaty. I can't remember right off. But Article 2 plainly says, it talks about the people of African descent. And it's almost the same language of the United States the United States Constitution, Article 13, Amendment 13, 14 to 15. So I encourage everyone, and especially the people at the Creek Nation, the National Council, you could change the laws. This could be changed quickly. This can be done. And I believe it doesn't take a popular vote by the citizens. I don't, because when you read all the laws, the things that the National Council has approved, you can see this can be done by the National Council. So I just hope the Creek Nation does the right thing by fully complying with the Treaty of 1866.
You kind of touched a little bit on some of the instances throughout history where the Muskogee Creek Nation as a government in negotiations with the government of the United States has, the different laws and how they've impacted the tribe. And it seems like anytime we deal with federal input or federal guidance, there's something at stake to lose for the Creek Nation. Do you feel like that's probably the case here? Like once, we talk about self-governance and sovereignty, what are your thoughts on that particularly and how it pertains to the freedmen?
Ms. Ellis, you're exactly right. I believe this could hurt the Creek Nation in ways because, again, this word I'm gonna use, comply. They're not complying with the treaty, and even the United States Supreme Court plainly stated that this is now and has always have been a reservation. So I believe there's a lot at stake, not just for the Creek Nation, maybe for other tribes. So they're headed down a slippery slope when they're dealing with things like this. But I just want the Creek Nation fully comply. Fully comply. That's my main concern.
One of my concerns, being just a citizen of the tribe right now, and working for the tribe and seeing the climate play out with the way that the state and our tribes are having to really, I feel like tribal governments are having to advocate strongly for sovereignty right now. It almost feels like a sovereignty full court press. So my concern is with the governor of Oklahoma already requesting disestablishment from Congress. Does any kind of federal involvement right now mean that we're possibly, letting the snake in the hen house, so to speak, is what I'm concerned with. So I definitely sympathize with and understand where you're coming from when you say that there's a slippery slope, and I feel like there's always something on the table that we have to like watch out for when it comes to dealing government to government with the federal government. So
absolutely. So I mean, that's a great statement right there. I just don't want, the tribes have a great leverage, with that, the Treaty of 1866. And that's a excellent leverage to have, because when the Supreme Court made a ruling because of that treaty, it's fully, it's fully alive, it's fully functional. So the treaty to me says it all. The Creek Nation can have a constitution, like I stated earlier in this interview. I'm 100% behind sovereignty. Self-governance, I'm 100% behind that. But when that sovereignty infringes or disenfranchise a class or race of people, that's totally wrong. This is like the United States saying, okay, you must have 3/4 American blood to be an American citizen or U.S. citizen. It's totally ridiculous. You don't have to have any U.S. If you're a U.S. citizen, you are a full-blood American. I don't care if you are 1/2 Creek or Cherokee, 1/4. Any Creek citizen, Cherokee citizen, Seminole, anybody could run for office, president, or for Senate or House of Representatives. So that blood quantum was I go back to that because that's everybody's who, as a citizen, that's their hang up, is that blood quantum. And they look at it like freedmen don't have them. In my studies, freedmen do have blood quantum, but that is not what made us citizens. What made us citizens, and what even made the blood by blood citizens, was the treaty. Just think of what, nobody had a treaty. Oh, we'd be hard pressed to getting any type of rights. But it's the treaty is what made us citizens of this nation. Period. Point blank.